Good morning, everyone. Welcome to the Council Planning Committee's third work session on residential renter barriers concerns. With me on the committee is Dan Hamill and April Barker. We're going to begin with introductions, so go ahead, Mark.
I'm Mark Gardner, Legislative Analyst for the Bellingham City Council.
Peter Raffato, Bellingham City Attorney.
Kimberly Huizinga from Landmark Real Estate Management.
Laura Magi, Property Manager from Landmark Real Estate.
Okay, so I think we'll hear from both of you first, and then we'll go from there.
Good morning. Thank you for inviting us, April. I appreciate it. So I've reviewed the last two meetings and just brought some of our concerns from a property management side. Sure. So just brought some notes and ideas as we represent the ownership side. So just some statistics that I was able to pull, but since January 2015, we had 16 residents that were on Section 8 housing that vacated properties that we managed. And of those 16, 10 left owing an uncollectible debt in excess of $7,000. So that's a 62.5% rate. Company-wide, we had 147 move-outs out of 1,106 units, and 13.3% left uncollectible debts. Some of the concerns that we have, which we're willing to mitigate, by the way. We just want to share some of our concerns that we're having, but the loss of rent when we have to wait for BHA or Section 8 to perform interior inspection. So as you know, right now vacancy rates are very low, and every day, if we prorate rent, is a day of lost rent. So we're having to wait for the inspection to happen. Also, we are noticing a lot of units that have passed the city safety inspection that don't pass the Bellingham Housing Authority inspections. So that's a concern to us and property owners. A lot of older properties that are passing the safety inspection, but they're not passing the Bellingham Housing Authority inspection, and so owners are then having to put more money in to do repairs that maybe they don't feel are 100% necessary.
So the Housing Authority does inspections also on top of the rental inspection? Right,
and if you have a unit that's part of the Section 8 Bellingham Housing Authority program, your inspections through the city are waived, which is a positive, so you're not having to pay that inspection fee. Also, there is a delay in receiving the deposit from Section 8 and Bellingham Housing Authority to secure the unit. So just waiting for those funds to come in. So typically what we do is somebody's interested in the unit, they bring in a cashier's check or money order for the security deposit, and it holds that unit specifically for them. And then one of our other concerns is housing assistance funds don't go directly to the resident. So those are funds that go directly to the property management company or the landlord, and therefore when the tenant moves out, there's no funds to pay for damage in excess of the security deposit, because now the program is no longer contracted with, let's say, Landmark Real Estate Management. Therefore, we only have the security deposit funds, and I think that that's kind of shown in the uncollected debt that we've experienced. Just some concerns that we've noticed with some of the Public Housing Authority contracts is the Public Housing Authority contracts have no liability or responsibility to the owner or other persons for the family's behavior or the family's conduct during tenancy. So a lot of times when people don't have the financial access or do not qualify financially, we'll ask for a co-signer, and the co-signer would be responsible for family behavior damages while they're there. Also, PHA, and when I say that's Public Housing Authority, the PHA may terminate the contract if the PHA determines that the contract unit does not provide adequate space in according with the housing quality standards because of an increase in family size or change in family composition. If the family breaks up, the PHA may terminate the contract. So those are obviously huge concerns that we have, that with any other lease agreement that we have would not be enforceable. So whether the family broke up or there was additional family members, if they're on a one-year lease, they would have to remain on that lease term. Not that we've dealt with this issue, but this was a concern when reading over their contract. The tenant is not responsible for paying the portion of rent to the owner covered by the PHA, housing assistance payment, under the contract. A PHA failure to pay the housing assistance payment to the owner is not a violation of the lease, and the owner may not terminate the tenancy for non-payment of the housing assistance payment. So again, I mean, that hasn't been an issue, but if for some reason funds stopped or we didn't get a check for some reason, we wouldn't be able to terminate the lease based on that. And then another concern is after the initial lease term, the landlord may terminate for good cause, including tenant's failure to accept the owner's offer of a new lease or revision, the owner's desire to use the unit for personal or family use, or another purpose other than residential rental, or a business or economic reason. So our concern with that is with any other tenancy, it's just a at-will tenancy at the end of the contract. If for any reason we've been unhappy or they violated the lease or there's been complaints, we're able just to give them a 20-day notice and move on to a new potential candidate. With this, I kind of feel like we might be stuck with the resident. And then finally, the owner must notify the PHA of any changes in the amount of rent to the owner at least 60 days before any such changes go into effect, where with the tenant landlord law, it's a 30-day notice. So just, we've noticed some discrepancies in the time frame when you're under assistance program. So those are some of the concerns, and maybe I'll let Laura just touch briefly.
Sure, go ahead.
So just a clarifying question.
Yeah.
If, under Section 8, if a landlord chooses to increase the rent, they have to give the 60 days. Is there also a time that then whoever's doing the Section 8 can decide if they can increase? And then if they can't at that time, what happens?
You know, and I know you had asked me that before.
Yeah.
We've never experienced it where it's come back and said, no, they won't qualify. So, because we haven't worked with a significant amount of Section 8, but that is a good question.
Thank you.
I'm not sure. So,
Go ahead, yeah. She'll get you a microphone. She'll hook you. That pretty well sums it up, doesn't it?
I can just come in when necessary. No need to do that.
Terminals.
Go ahead, Mayor.
Okay, and this is just something I read quite a bit from other cities about housing and how they take care of some of the concerns that we've heard here in the city. Kelly Linville, Mayor, sorry about that. One of the things that I just recently read was a payment system for first and last month's rent and damage deposit, so that you don't have to come up with that great big hunk of money at the beginning. And I haven't heard anybody, I've only been to 1.5 meetings, I haven't heard from anybody say that that's something we do here. So is it?
So what we typically do is unless the prospective tenant is a student, which we require a cosigner, with pretty much any other circumstance, if the resident is not able to pay last month's rent, they have the option, a cosigner or last month's rent. We've done that occasionally, but typically no. We like to collect that up front.
Go ahead, Laura.
So I work primarily, or I help start the wonderful relationship that we have right now with Lydia Place. It started about 30 days ago, 45 days ago. We had a first meeting, and then the idea with bringing in Lydia Place, some of their clients do have Section 8 housing vouchers. Some of them do not have Section 8 housing vouchers, but Lydia Place does have funding. So what we've been able to do is speak with some of our ownerships of our privately owned homes and or apartments, and encourage them to take a lesser amount of money for the from the tenant or from Lydia Place, and primarily just out of good cause, a feel-good situation. And so far I have 3 units, and we have 5 more coming on board. I've got 2 more. So this is a program that the partnership has just begun. Through this, I've had a history of Indian housing and public housing and subsidized housing tax credit. I sat in this meeting wondering, when we first began the partnership, if this would be successful. Because of what I've seen in the past of a lot of Section 8 housing vouchers just going by the wayside. People didn't care about the units, and the only reason why I was willing to step up and say I think that this can work is because of the case management that Lydia Place provides with their Section 8 housing voucher and or the other program participants that come through. They do weekly, monthly program engagement. They do a thorough assessment before the person comes on our property. We look at the history of the person. There's a lot of communication going on. So I'm here to say, with everything that I have seen in my 20 years of housing, that if we put more pressure on our public or on our homeowners to take Section 8 housing vouchers, the only way that I see that it will work, and Lydia Place said the same thing this morning, 80%, they have an 80% success rate if in fact there's case management involved. If there's not case management involved, then there's program failure. So with their 80% success rate, they pull in program management and placement into the home or to the residence, the unit, whatever it is. So, thank you.
And just to add on to that too, so some things that we're doing to incentivize owners to participate in this program is we're actually waiving our management fees. And the other great thing about this program is that the residents are in counseling. They have help with finding jobs. They have help with budgeting. If they didn't qualify, they put together an actual letter explaining their past and what has happened and what their plan is to get acclimated back into the community and be successful. So what other things are we doing for ownership to get involved?
We are going to, at some point, be putting together some kind of incentive program for them. There will be publicity and things coming down the pike. That hasn't happened yet. Right now, it's just one-on-one speaking with the ownerships and letting them know what the potential is and the reason why housing is needed in the area.
Dan?
Try to form some thoughts here. So I think it's not widely known that private ownership contributes to housing for people widely through our community for folks that have some type of subsidy. I think that the the common image out there is that there are like projects or housing units and things like Francis Place, when that's really a smaller percentage than what we're talking about today. So I just want you all to understand where I'm coming from when it comes to what we're talking about here with source of income discrimination and other things that barriers to housing. So I'm a Ward 3 representative, so my ward includes Roosevelt, downtown, Sunnyland, other areas that have folks that can barely rub two nickels together when it comes to trying to make their rent plus their food and other costs. So I'm very much aware of their situation. I'm trying to protect them as much as I can. So a question and then some comments. So do you take, in addition to Section 8, do you take VASH vouchers, veterans vouchers?
We've worked with a lot of programs, and basically anybody that receives income like Social Security benefits or veterans benefits that go direct to them, we do not discriminate against. It's money that's going to them. We consider that part of their income. So basically the only time that we've said, like this property will not accept Section 8 is because the ownership has decided that they don't want to work with that program. But as far as I'm not super familiar, I don't think, with the VASH program.
Okay.
Is that money that, again, that they're paying direct to the landlord, or is that money that goes to the tenant?
My understanding is it's housing assistance. I don't know where it lands in terms of the tenant or the landlord. What about tenant-based rental assistance program through like Opportunity Council or Catholic Housing? Is that part of the
Yeah,
profile as well?
this is the Public Housing Authority system.
Okay. So what I'm trying to get to is we have a very low vacancy rate, as you know. And what happens is it puts people in really terrible situations. So we have families that we may have a person living with an abuser, and that person is trying to break that relationship, but that person may not have options in terms of being able to move because of the vacancy rate. So I want to make sure that person has options and is able to move. And if housing assistance is part of that person's financial picture, then I want to make sure that person can use those dollars to move into another unit. I think there's no dispute. I think that the community would support that person being free from that abusive situation. There's also folks with developmental disabilities, veterans who have served our country, and families with low incomes, and I'm all about protecting and making sure that they have options in terms of mobility and the ability to move. Families that outgrow their current residence or have some type of changing circumstances that forces a move. So all that to say, what I'd like to get to is some type of arrangement, understanding, policy ultimately that will benefit the people that I'm talking about, but also understanding that our owners rather are providing a service in effect for the community. So I want to honor that as well. But I don't want it to come at the expense of people with low incomes. I feel like they often don't have a voice, and they often are marginalized. So I want to make sure that the highest level of protection is afforded for them. Mm-hmm. So that's my perspective. I just want to lay that on the line and make that transparent.
Yeah, no, I think that's fantastic, and I think that's a goal that we would like to be a part of. The biggest thing is just protecting the property for damages. I think that's our biggest concern upon move out. Just statistically, we've seen more damages, unfortunately, come from the programs where the money is not going direct to the client, because then once they move on to a new program.
So Landmark doesn't have a policy of not taking Section 1. It's the owners, your bosses.
The property owners,
your bosses.
exactly. Yeah. So, because we're all fee-based, so we don't own any of the properties we manage, so it's just on a case-by-case basis, or some landlords.
So out of all the units, how many different owners are there? Do you know that?
I'm going to say approximately 400.
400 out of all those units? Okay. Uh-oh. Oh, I'm sorry. Go ahead. Turn your mic on, Mike.
Hi. Could you tell me how many rental units you manage?
We manage about 1,300 residential, and then we also have just under 500,000 square feet of commercial.
Okay, and of those residential, those 1,300, how many have left for uncollected debt overall outside of?
So since January 2015, 147.
147. You mentioned in your comments that the BHA, the Housing Authority, won't pass a property, but the city's inspector. How many times has that occurred?
That's pretty frequent. The BHA will go in annually as well, and so the safety inspection is waived, but we're finding things in those inspections, and Laura might be able to touch more because you're seeing directly the reports, but things that won't pass. But the safety inspections will pass with flying colors, so I might have Laura touch more on what those items would be.
The city's safety inspection will check the smoke detectors, carbon monoxide monitors, all of the smaller safety features. The Housing Authority or the Public Housing and Safety Inspection goes a lot more deeply into room size and the size of windows. There's a lot of different GFI outlets. Yes, is another one in the kitchen and those are the common ones.
Screens.
That's right. Screens to window coverings sometimes.
Yeah, and to be fair, there are different purposes for different inspections. They're not the same. The city's inspection is to deal with life safety, and life safety exclusively. BHA is more comprehensive in their looks. So there are going to be circumstances where we would find a failure of BHA, but a passing of the city. Again, the city's checklist is not as expansive as the BHA's.
April, Mayor? Go ahead.
It was just me.
Go ahead.
I just want to emphasize a point that you brought up that I think is really, really important because I know of circumstances where this happened, and that's the supervision. Because I know of at least 4 rental units that are not available to low-income people because of the lack of supervision from the authority that was getting the money, and then communication based on the checks stopping and not knowing. So I don't know if that's because they were going directly to people or whatever, or it might have been, going to the person and they just assumed it was going to keep going. But I think that supervision for subsidized housing, for vouchers, if we want to get them available for everybody, and plus, if people need help, I think the supervision is really important of whoever it is, whether it's Lydia Place or Opportunity Council or whoever else does, or whoever does it, whoever's doing it. I think it's extremely important, so things don't get kind of snowball, like you were saying, on any kind of damage or health circumstances that mean that someone isn't paying their rent or whatever it could be.
Go ahead, Dan.
No, I think that's a good point. I think the case management component that you brought up, Laura, is I think important. I'm just a little worried that it's not always necessary for. Not everyone needs case management that lives in poverty. It's just not the case. So
well, I want to just make sure I'm not casting any aspersions upon people to get Section 8 vouchers, but just the regular, how often it need to be, just inspections on the property. And then at whatever level, if someone does need more help, that's a great way to find out. But just to make sure, if it's quarterly, if it's, you said some are yearly, I just know that this has happened, and now 4 families don't have a place to stay.
Sure. No, I don't think I'm in disagreement with you, Mayor. I guess what I'm saying is that where case management is needed, it should be applied. I think that's a no-brainer. In situations where it's not needed, I think that's where we might be running into some issues where there's damage to the property or to the unit. So what I'm trying to get to is a common ground on, like I said before, what's going to work out best for people who have very limited options, and what's going to work out best for owners who are providing these living quarters for folks. So what I hear is that there's delay in payment sometimes, or often maybe, that there's damage that exceeds the security deposit, which is not recoverable. So that's an issue. What I've heard from the Opportunity Council is that that with some of their programs that there is a guarantee to the owner, and I'll have to circle back with their executive director to determine what that looks like. What I'm interested in is trying to figure out a way to kind of close that gap so that owners get the dollars that they need to repair the unit if there is such damage, but also for folks who are not really creating problems, but they're kind of falling into this kind of catch-all bucket category, which I think is not right. So that's what I'm trying to get to, and there's been ideas floated around having a third-party guarantee, so maybe like a foundation that could have some dollars that would that could go towards this type of damage, or security deposit or move-in costs, that kind of thing. So I'm interested in looking beyond what the city would do, but maybe what a third party that's interested in housing justice might be interested in providing.
Well, I want to thank both of you for coming forward, and Kim, it's been great to work with you, and I've learned so much kind of about the process and when you're managing several units, as you both are doing. I also want to commend Landmark and what you all are doing with Lydia Place. I think it's a really great example, and hoping that other management companies will see that leadership and continue with that. I also want to thank you for coming in. I know that you've brought up some really specific things, and that's exactly what we need as we move forward. So I'd like to keep that communication open, and feel free to get in touch with us. And as we move forward in this process, it's kind of why we wanted to start with this. We wanted to go slow to go fast. We want to make sure that we understood all the different stakeholders involved, but also at the same time, we need to make sure that we're protecting our constituents as well. So, what I hear from you is that you also want to do that, and you want to make it work for both. So I think this is probably a good segue for Mark, because you've been doing some research on what other municipalities are doing, and I think that might be helpful. I think also there was, maybe to start with, I'm trying to remember the memo, there was a specific bill that was passed at the state level for funds that could be used, but they've never been used. Can you talk about that one? Do you remember which one I'm talking about?
Sure. I don't remember the part of the RCW it's in, but it was passed as part of a set of other bills, and it sets aside a relatively small amount of money for basically to backstop liability issues if Section 8 or other income subsidized tenant causes damage that exceeds the deposit, the owner could apply for these funds, but it only applies for cities who have a source of income discrimination ordinance in place. And it also requires an adjudicated finding that it was the tenant's fault. And I don't know if that's a barrier to the funds being used, but they actually haven't been tapped into, so they're sitting there in a state fund, and I think it hasn't been in place all that long. I believe about maybe a year, or maybe it's two, but nobody's used it yet, so maybe they don't know about it, but at least as a general model, if it could be made workable, would provide some sort of backstop.
But you have to have a no income discrimination ordinance on the books to apply for it.
That's the way they wrote it, so
Okay.
it's kind of
Dan.
an interesting trigger.
So those dollars are probably not like just readily available. It's not like the owner would say, there's $5,000 worth of damage, please write me a check, right? There's a process that it would go through adjudicated, so that's a court process, and that would take some time to recover those dollars, and then theoretically that unit might remain offline to not be able to rent it. Is that a likely scenario?
Well, I think that could happen in any case if there's repairs that need to be done, and I don't know how adjudication would affect the ability to re-rent. I assume if you document it and then go into a court case, but I'm suspecting that it's the adjudicated finding of damage that is maybe the issue, that people are saying it's not worth it. Plus, there is a threshold you have to meet for the level of damage to kick in, and I did ask the person who oversees it why he didn't think there was uptake, but I didn't hear back from him yet. But it's there. It's an interesting idea if it could be made workable. If there's some barriers, it could be removed.
Go ahead.
So is it your understanding that this is not being used at all at the?
That's what I was informed, that nobody's ever applied for the money. Some public entities have applied for it, but they don't qualify, so it's
Right.
only for the private market.
So there are about, 12 or 14 different cities and jurisdictions in Washington State that have a source of income discrimination?
Yeah, and
It's
it
about
hasn't
that.
been utilized. I think it's about $150,000 that's sitting in the budget.
Okay, go ahead, Mark. You want to finish or start your report?
Sure. I was, the planning committee meeting before last, I was asked to take a look at a few sets of measures that have been put in place in various places to protect tenants, and those are source of income discrimination ordinances, an ordinance regulating move-in fees that Seattle put in place, and the third area was looking at notification of tenant rights measures. And there's a memo in your packet that provides a moderate amount of detail. This is a kind of a big picture overview. Not really in-depth research has been completed yet, so additional research would be needed if there was council interest in pursuing any of these. But just to review briefly what's in the memo, starting with the source of income discrimination ordinances. These target practices of some rental owners or management companies of not renting to households where rent payments are derived from sources such as Section 8 vouchers, veterans vouchers, or disability payments. Research has shown that income non-discrimination laws have modest effects on reducing neighborhood segregation, but in particularly tight rental markets, they may be critical in assisting some people in getting housing at all. Another issue that has come up recently is that more and more cities are embracing a rapid rehousing strategy for tackling homelessness, and vouchers on occasion will expire before a person finds housing, which destabilizes the person if they're trying to find employment, or if it's a family, the kids are disrupted in their schooling. So that's a big issue. Up and down the I-5 corridor, the number of jurisdictions participating in Section 8 is declining. I've asked some areas for specific statistics. I've gotten a couple pieces of data in. I will continue to collect that. But both in Vancouver, Washington, and in Whatcom County, the number of landlords participating have dropped by 20% in recent years. So as a result of these trends and these issues, more jurisdictions are enacting source of income discrimination ordinances. 14 states, a total of 60 local jurisdictions. The number's probably a bit higher than that now, but as there's continuing legislation regarding this, and there's at least 10 in Washington. And these ordinances vary a bit. Some just focus on Section 8, but increasingly there's concern of discrimination being expanded to other sources of income, including veterans payments. So some cities are specifically broadening their definition. That's a trend at the local area. Just to read a few pieces of language from some of these ordinances to see how they're constructed. It's useful to see the different approaches. This is from Pittsburgh, and it reads, all lawful sources of income or rental assistance program, including but not limited to earned income, child support, alimony, insurance and pension proceeds, and all forms of public assistance, including federal, state, and local housing assistance programs. This includes the Section 8 Housing Choice Voucher Program. Vancouver, Washington, this has been heavily modeled in our state as a good definition. It reads, income derived from Social Security, supplemental security income, other retirement programs in any state, or any federal, state, local, or nonprofit administered benefit or subsidy program, including housing assistance, public assistance, and general assistance programs. Ann Arbor, Michigan takes the opposite approach, and they say source of income, any legal source from which a person obtains money. So that's another approach, but it's very broad. And so I don't know if that would include a regular successful gambling person, or so possibly it's too broad. And I did hear from some organizations that they felt some enumeration of the specific areas is useful in enforcement and education. But this would need to be looked into about the different sources. And one issue I know that owners are concerned about is stability of income. So to the extent that a definition included unstable sources, that could be a problem. So we want to look into the definition if you're interested in proceeding this way. There's some other jurisdictions that have added some language about how landlords are to calculate income adequacy if they take various forms of tenant-based rental assistance or vouchers. In Seattle, Vancouver, and Auburn, ordinances stipulate that voucher amounts are to be subtracted from rents before income to rent calculations are made. So they're directing the owner to calculate it in such a way that the amount of rent that the renter actually pays is what's compared to the whatever the standard is. So they're not telling people how to set their payment standard up. For example, like 2 or 3 times a monthly rent is a common standard, but they're saying you have to do the calculation in a certain way. This greatly enhances the number of people that qualify under those kind of formulas.
Definition of insanity. We heard about this at the town hall. There was a particular constituent who came forward and said, I have a Section 8 voucher actually going to a landowner that's willing to take it, but because they won't use that in her income, she doesn't make enough in order to, even though she'd be able to afford the place. So I think that is certainly something, if we go forward, we need to tag that to make sure that we get some feedback from different people on why would that be an issue for management. And I don't want to put you on the spot, so if you're not ready to answer it, it's no problem, but if you were accepting Section 8, do you have particular thresholds people have to make financially in order to get, and then if to get the unit, and if do you take out that Section 8, do you consider that as part of their income?
We do consider the Section 8 as part of their income.
Excellent, thank you.
Well, that's no problem at all. It's an important issue. In terms of enforcement, I did just a very moderate amount of research, so additional research would be needed. But what I've heard is that some housing professionals have reported that these ordinances reduce the incidence of outright discrimination, which they see as a value in and of itself. But also that large property management companies are likely to comply because they're generally risk averse and they don't want to be wasting their time being pulled into court or otherwise dealing with compliance issues. So they felt that there was a certain amount of almost automatic compliance, but they noted that outreach to both landlords and tenants is important in getting compliance. People need to understand what's in place, but also how it works. Most local ordinances have a backstop of being enforced by complaint, and in this case, voluntary compliance is usually attempted. And I know that's how Bellingham works. Start with voluntary, and then after that, an escalating series of penalties may be invoked to attempt to achieve compliance.
Who enforces that? Is that their what departments handle that? Would be.
Well, I haven't really looked into that.
Okay.
I assume it varies. It's in some cases it's the planning department. In other cases, it could
Code
be a legal,
enforcer, probably.
or it could be a general, or like a civil rights unit, depending on the city. Some larger cities have general tenants' rights enforcement mechanisms that might be separate from planning. But so I think it varies quite a bit.
Yeah, I did speak with Mike Chen with the Civil Rights, I guess it's a department in the city of Seattle, and he did mention that these larger jurisdictions, they have that, so they have some teeth and they're able to go after it, but then there's issues with smaller jurisdictions like ours where we don't necessarily have that ability. So it would also behoove us, I think, to talk with other municipalities that have done this to figure out how they go about it, because I'm sure that will be a major concern among constituents, that if you have something, how are you going to actually enforce it?
Just a few other notes on enforcement. In some cities, community groups help publicize the ordinance and may help tenants understand their rights, and in some cases, legal or renter advocates may assist with enforcement. And there's a lot of different ways that cities can set up the enforcement apparatus. I've had short conversations with Peter about this. This is something that would need additional research to make sure we had something in place that would work for all parties, but that would actually provide a real backstop when needed. And that's all I have on enforcement. Just to note that there's a number of other provisions that are in various ordinances. This varies quite a bit by ordinance. But some cities explicitly say that if the units are not eligible for vouchers for particular reasons, they're not included in the regulations. That's just a kind of to reduce the tension, I guess, that might be might result if all owners felt they had to somehow participate regardless of the rent level or whatever. So there are some legal reasons why entities do not qualify, and so they wouldn't be included in any enforcement. However, Auburn adds the following provision to their ordinance: refusal to allow a health and safety inspection of the property by a public housing authority or subsidy program inspector shall not be considered a legitimate basis for refusing to rent due to program ineligibility. So they're saying that if you would otherwise qualify, you can't just say we don't want to have an inspection, therefore we're not covered by this ordinance. A number of ordinances also note that legitimate reasons can be invoked to deny housing or voucher holders actually being brought into a unit, such as a tenant's prior history of violence. So there's many legitimate reasons that would still allow tenants to be screened out. It just can't be on the basis of income source. Now I want to switch gears here a little bit. I was also asked to look at the Seattle ordinance that regulates move-in fees. So I've just briefly got a few elements of that ordinance I wanted to review. In Seattle's case, they were concerned about the total upfront costs of moving being prohibitive for low and moderate income renters, being concerned about increasing homelessness and people not being able to move. There's a lot of rapid rent increases up and down the I-5 corridor, but particularly in Seattle. So this ordinance regulates upfront fees and requires that landlords offer a payment plan. And just to discuss some of the provisions of this ordinance, the total amount of a security deposit plus any non-refundable move-in fees may not exceed 1 month's rent. Second, total non-refundable move-in fees cannot exceed 10% of the rent. This does not include the cost of any screening reports. A pet damage deposit cannot exceed 25% of 1 month's rent. So they've got a series of limitations on the upfront fees. In general, they have to be allowed by state law is one of the stipulations as well. And the second provision of the ordinance is that payment plans are authorized up to 6 months if there's a long-term lease, and there's various other stipulations for shorter payment plans to be set up depending on the situation. So I'm just going to pass out a diagram that discusses the basic formulas. Yeah, I think so. It's kind of a nice little simple to understand diagram. It's from the city of Seattle. I can't take credit for that. So that's their ordinance that regulates both the types of fees that can be charged and requires payment plans. Just want to note that there's been a lawsuit about this, so this is something worth looking at as in case there's any consideration of this provision. It makes sense to pay attention to what is happening legally. Just briefly, one other thing I was asked to look at, and then I can answer any remaining questions you might have. I was asked to look at tenants' rights information, and this one I've got a few sentences on. A lot of cities require tenants' rights information to be distributed at the time of lease-up or renewal. For example, Ann Arbor requires distribution of rights and duties of tenants booklet. This is interesting. It's written by the city, by tenant advocates, and by owner advocates. So they let everybody have their editorial say in this booklet, but it's actually required in their city charter. Seattle requires that an information for tenants publication be distributed to each prospective tenant and to existing tenants when a lease is renewed. And our own code requires that tenants be provided with written information regarding tenants' rights and resources. There's also stipulations about the certain information to be provided on the city's website, which is already been in place for quite some time, even before this provision was in place. I know that planning is currently working on expanding the availability of this information, both at the certificate that's required to be posted in the unit that indicates registration, and also at the inspection process. And I don't know if Rick wants to add anything to that, but
go ahead, Rick.
we are doing some work on this area.
Thanks, Mark. Indeed, we're looking at the rental registration certificate that is posted in the unit. We think folks generally put those things aside till they need them. And if we had a place that they're able to find a link to a website or have those materials, it's useful. Additionally, we're working on probably using a second sheet on that document that's posted that would have all the links there. As part of our inspection, we're working on developing a brochure that would have a little more text in it, a little more information, and we'd be able to distribute that as part of our inspection process. Just leave it in the units or provide it for those who use private inspectors. We think that we can get broad coverage with those uses without any additional regulatory fix at this time.
Go ahead, Mark, you've about
And
finished.
That's pretty much what I have. I've also put in the packet a two-pager from the Bellingham Housing Authority that discusses some of the mechanisms of how Section 8 works. I didn't include a lot of that information in the memo, but that's just some background about how the program works from their perspective as administrators of the program.
Okay.
And that's pretty much a brief overview of what's in that memo. If there's any additional questions I could answer,
Yeah.
let me know.
Thank you, Mark. April?
I also, for anybody that's watching or decides to watch this later, you can go to the city's website and where you'll be watching this video, and there's a link there that will have all of the handouts there. When he keeps mentioning the packet, I think it's important that those links are there. And then anything that we've received, we also put, so once it posts, once we get our minutes approved, so it might take a week or two, then all the new documents will also be there for people to look at. Also, if anybody's just now coming into this conversation, this is our third meeting of this group, so you can also email our city council, Marie, actually, her legislative assistant, and she will be able to direct you to the other videos so you can kind of catch yourself up on the process that we've been through.
Okay.
I just
Mark.
want to mention one thing, that this diagram is in the memo in the packet already, so,
Okay.
but I wanted to have a
Okay,
bigger
now we-
version for you.
We usually have 10 minutes for public comment. Anybody out in the crowd want to come and say anything? Come on up there, Dick.
Good morning, Dick Conaboy, live here in Bellingham. I'm especially, as a veteran, I'm especially interested in what applies to veterans in this topic here today. And thanks, Dan, for bringing up the VASH vouchers. I don't know, I'm not an expert on those. I was recently appointed to the Whatcom Veterans Advisory Board by the county executive, and I've chosen to look at these kind of issues that have to do with veterans and housing and homelessness. And I'd like to, I haven't seen all of these meetings, but if you haven't had any of the reps from over in the county, because they also do cover Bellingham with respect to veterans issues, that you get somebody in to talk about the particular issues that are facing veterans with respect to using their vouchers or any other subsidies that they might get from the government, be it state or federal. That's all I got.
Okay.
Thank you.
Thank you, Dick.
Perry Eskridge from the Realtors Association. Something I wanted to point out that, I don't know, it seems to be sort of par for the course when we have these discussions is we always point out the problem and everybody jumps on the one that's the most public, but I haven't really heard anything about how you're going to deal with the landlord's concerns about how the housing, the Bellingham Housing Authority deals with the deposits. I mean, you heard a lot of, well, you heard the two big property managers talk about the fact that they don't mind using Section 8 if it weren't such a hassle with the Bellingham Housing Authority. So, I mean, it seems to me like you could solve that problem a lot easier than, going through a whole regulatory, process on this. It doesn't seem that the number of incidents of discrimination or supposed discrimination that we've heard about really warrant doing all of this work until you've taken care of all of the other things that we can control. The other thing I want to point out is we've met with the Bellingham Tenants Union a couple times, met with the Western Washington University group a couple times, and we keep offering to do this education. When we did rental registration, we were supposed to have an educational program. Remember that? We were supposed to be out there talking to the tenants about education, and the Realtors Association has offered our property managers, they've offered my services, they've offered everything, and nobody takes it up. So I just want you to know there was supposed to be this whole educational component that went with the rental registration thing, and it's not happening. So before we go down more and more and more regulation, let's at least, try to accomplish the things that we can fix now that don't require more ordinances and those things that we promised to do at the outset. Okay? Thanks.
Thank you, Perry. Go ahead, April.
So a few clarifications. Thank you both for speaking. And Dick, that's a great idea. And I think in our next meeting, I would like to invite somebody from the group. I also have, how did I write it down? I had a suggestion, and I did speak with Kelly Owen of Northwest Justice Project, and she'd really like to come to one more meeting if we could have one.
Okay.
She's been really researching this quite a bit and has some suggestions if we do want to go forward with any type of legislation. She'd like to have that moment. So I think those are beneficial. I think getting some more information from staff at Vancouver, since that seems to be the model ordinance, would be really good to maybe have a meeting with them prior and then bring forward some more information from those programs. Also, the clarification, I think when Doug was here with, was it Windermere Realty or Property Management, no longer does Bellingham Housing Authority, they're not involved in the security deposit. So it is up to the tenant to pay the security deposit. And I know in the past that is the case, but that's also in the memo that Bellingham Housing Authority did clarify that they deal with the voucher. And is that correct? You don't experience going to Bellingham Housing Authority for the security deposit, correct?
It's typically the Opportunity Council that has been providing the security deposit. So it's separate funds.
Separate funds. Okay, thank you.
Mayor.
Well, and I'd just like to follow up, because I remember I was here when we did the housing inspection, and we did talk very much about I think Mark mentioned Bellingham Way is to give incentives first, and it's education, technical assistance, incentives, and enforcement. And so if we're not robustly doing our education, and I don't think that means the city doing it, but it certainly would help if property managers and others had some responsibility in doing some of that, then I would really like to see that happen, because I think sometimes we lose our credibility when we say we're going to do something, and then it does or doesn't happen the way people expect it to.
Rick?
I'll note, we'll be hearing at 1 o'clock today the Town Gown, which is an extensive program working with Western Washington. We've done it for the last year on getting outreach to future tenants, talking about the rules in housing and rental. We have a very well-attended event called Housing with Hash Browns. We've run it twice now. Many hundreds of students attend who are about to go into the market. It's a great way to introduce information, and those are some of the ways we've been using to disseminate the message. So today we'll be talking about that, actually, as that strategy moves forward.
Well, I know the realtors were very instrumental in talking about the education piece, so I think it's important that we respect their role, because obviously you're in the private sector doing these programming, and the more in the private sector we can get that are doing the educating and participating, the better off we're going to be, because every property has someone who's managing it, whether they're a company or an individual. And I think it's good to have the students also educated, but we have a lot more people than students that are renting, obviously, in our city, if we have 54% people renting rather than home ownership. So I would just encourage us to include everyone who wants to help.
Okay, so is there agreement on our next meeting then, what you laid out? That's fine with me. Is there anything else?
Mark,
ahead.
thank you so much for,
Yeah,
I know
thank
that
you,
took a
Mark.
lot of time, and you really brought it in very succinctly, so I appreciate it. And then we'll work with you as far as maybe getting some meetings between now and then with some staff from other jurisdictions to bring forward more information. So thank you very much for that. And thank you for attending,
Yeah, thank
Mayor.
you,
It's
Mayor.
great.
Well, I was going to sit in the background like I like
No,
to,
no,
but
no,
I got
you
to
can
talk,
do
so
it.
of course I was happy to come.
Okay, thank you very much. Meeting adjourned.